This is a summary of the judgment which the Supreme Court is handing down this morning in the case of Harcus Sinclair LLP against Your Lawyers Limited. This case concerns a dispute between two law firms, Harcus Sinclair LLP and Your Lawyers Limited, as to which of them can act for group claimants in relation to litigation concerning diesel emissions from vehicles manufactured by Volkswagen. The central issue is whether a non-compete undertaking given by Harcus Sinclair to Your Lawyers in relation to the contemplated group litigation is contractually unenforceable as an unreasonable restraint of trade. A related issue is whether the undertaking was a solicitor's undertaking, and if so, whether it is enforceable against Harcus Sinclair, which is an LLP, that is a limited liability partnership, and or against the individual solicitor, Mr Parker, who gave the undertaking on behalf of Harcus Sinclair. The non-compete undertaking arose because in return for sharing information with Harcus Sinclair relevant to claims being brought about the diesel emissions, Your Lawyers required Mr Parker to sign, on behalf of Harcus Sinclair, a non-disclosure agreement that contained the non-compete undertaking. By this, Harcus Sinclair gave an undertaking not to accept instructions for or to act on behalf of any other group of claimants in the contemplated group action without the express permission of Your Lawyers. The question the Supreme Court has to answer is whether Harcus Sinclair is liable for breach of that non-compete undertaking by acting through its corporate vehicle jointly with another law firm, Slater and Gordon, for over 43,000 clients with claims against the Volkswagen Group. The trial judge found in favour of Your Lawyers on the primary basis that the non-compete undertaking was not unenforceable as being an unreasonable restraint of trade. The Court of Appeal overturned that decision and found in favour of Harcus Sinclair on the basis that the non-compete undertaking was unenforceable as an unreasonable restraint of trade. Your Lawyers now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal of Your Lawyers. Lord Briggs, Lord Hamblin and myself give the judgment with which Lord Lloyd-Jones and Lady Arden agree. On the primary issue, the Supreme Court decides that the non-compete undertaking is not unenforceable as an unreasonable restraint of trade. This is because Your Lawyers has established that the undertaking is reasonable as between the parties, and Harcus Sinclair has failed to establish that the undertaking is unreasonable as being contrary to the public interest. A critical question of contract law that this decision lays down is that in determining what were the legitimate interests of Your Lawyers, it is relevant to take into account not merely the terms of the non-disclosure agreement, but also that the parties intended or contemplated at the time the non-compete undertaking was made a process of informal collaboration. Once one takes into account that informal collaboration, it is clear that Your Lawyers did have legitimate interests to protect by the non-compete undertaking. The Supreme Court also takes the view that the duration of the non-compete undertaking, which is 6 years, is reasonably necessary to protect the legitimate interests of Your Lawyers. That decision on restraint of trade is sufficient to allow the appeal. But the Supreme Court has gone on in its judgment to examine the law on solicitors' undertakings. A solicitor's undertaking is enforceable under the court's supervisory jurisdiction. Solicitors' undertakings are frequently given in litigation and in relation to transactional work, particularly conveyancing. But the question arising here is whether the non-compete undertaking is the type of solicitor's undertaking that attracts the supervisory jurisdiction of the court. The Supreme Court takes the view that it is not. The Supreme Court considers that in many cases, it will be helpful to consider the following two questions when determining whether an undertaking given by solicitors is a solicitor's undertaking so as to attract the court's supervisory jurisdiction. The first concerns the subject matter of the undertaking and whether what the undertaking requires the solicitor to do or not to do is something which solicitors regularly carry out or refrain from doing as part of their ordinary professional practice. The second question concerns the reason for the giving of the undertaking and the extent to which the cause or matter to which it relates involves the sort of work which solicitors regularly carry out as part of their ordinary professional practice. If both questions are answered affirmatively, then the undertaking is likely to be a solicitor's undertaking. But on the facts of this case, both questions should be answered negatively. In short, the non-compete undertaking was a business arrangement, and in giving the undertaking, Harcus Sinclair was acting in a business rather than a professional capacity. The non-compete undertaking is therefore not a solicitor's undertaking. Although not necessary for the decision, the Supreme Court also draws attention to a serious lacuna in the present law on solicitors' undertakings. In this case, the non-compete undertaking was given by Mr Parker on behalf of Harcus Sinclair LLP. But Harcus Sinclair, as an LLP, a limited liability partnership, is not an officer of the court. And Mr Parker did not give the non-compete undertaking on his own behalf, so could incur no personal liability under it. It follows that as the law now stands, solicitors' undertakings given on behalf of incorporated law firms, especially LLPs, cannot be enforced within the court's supervisory jurisdiction. This is a lacuna that we hope will be considered by Parliament. But for the primary reason that the non-compete undertaking is not contractually unenforceable as an unreasonable restraint of trade, the appeal in this case is allowed. I'll now hand over to Lord Legate.